Hi everyone, grab a drink and settle in. This is the Wills and Spills podcast, where we sip cocktails, unpack the most fascinating state disputes behind the court judgments. The podcast is about real people, real family disputes, and the wills that have sparked them. To help me spill the story behind our next case is Nick McColl from Equity Trustees. Nick initially joined Equity Trustees as part of the estate planning team in 2015 and has been in his current role as legal counsel since 2020. He's worked exclusively in estate planning, estate and trust administration and litigation, as well as general corporate and commercial. Nick is also an accredited specialist in wills and estates. Welcome, Nick.
Thanks, Linda. Thanks for having me on the podcast.
All right. So what case are we unpacking today?
So today we'll be unpacking, it's a case involving an intestacy, which is where someone has died without a will. And specifically in this case, it deals with how an estate is distributed on intestacy under the Administration and Probate Act, where someone dies with multiple partners and one of those partners seeks what is called a distribution order.
Yep. All right. So before we dive in, I want to provide a brief summary of the background to the case. So the deceased, Christopher Sheils, died at the age of 64 years old. Now, he died intestate, as you mentioned, which means he died without a will. He was survived by his partner, Sally Nicholson. However, at the date of death, the deceased was still legally married to Jembra, despite the fact they'd been separated for almost 20 years. He also had 2 children with her. Now, he left a modest estate valued at approximately $277,000. Now, Nick, in this case, the deceased was survived by Sally Ann, his domestic partner, and his wife. Now, as we know, the deceased died without a will, so therefore his estate is distributed in accordance with the laws of intestacy in Victoria. Can you please take us through how an estate is distributed when there are multiple partners?
Sure. So just briefly, a quick history lesson about how this was dealt with on intestacy prior to 2017. So the old system used to be where a deceased person left more than one partner. Each partner's share was determined on a sliding scale based upon the duration of the relationship. So this was a one-size-fits-all approach, which was modernised to provide a low-cost alternative for anyone who was dissatisfied with this process, in this case partners, who would otherwise have had to make what's called a family provision claim to challenge the distribution on intestacy. So it was also bringing us into line with other states and territories who have similar provisions, which is something we'll discuss a little bit later on. So under the current legislation, which is sections 70 ZA to ZE of the Administration and Probate Act, where a deceased person dies intestate and leaves more than one partner and children with one of those partners, the partners are to receive the whole of the estate, either in accordance with a written distribution agreement between those partners. So there's an opportunity there for them to come to some form of arrangement between themselves that's recognised. If there's no written distribution agreement, then in accordance with what's called a distribution order, which we'll come to a little bit later on as well. And in the case where there's no written distribution agreement and no one has applied to the court for a distribution order, then it is an equal shares. Subject to the administrator, and the administrator in this case will be the person who has applied to the court to administer the estate on intestacy, because unlike a will that appoints an executor, there is no appointed executor in this case, so it's commonly known as an administrator in this context. Mm-hmm. And the administrator is required to give the partners 3 months notice to either enter into a written distribution agreement or apply to the court for a distribution order. So in this case, the latter applied. So Sally Ann approached the court applying for a distribution order. Now, briefly, one thing that we'll probably touch on later as well is that if a deceased person dies intestate, leaving children who were not the children of any of their surviving partners, so in this case, Christopher left 2 children and Jembra was their mother, then the partners will be entitled to the statutory legacy, which is about $600,000 in this financial year, and one half of the estate. And the children will be entitled to the other half of the estate in equal shares. Now, as I said before, this wasn't the case here, as the mother of the deceased 2 surviving children was in fact Jembra. So really we're just dealing with a distribution order in the context of the 2 surviving or multiple partners.
Yep. Thanks, Nick. We'll unpack the intestacy laws a bit later. Now, Sally Ann, as you mentioned, she sought an order from the court that the deceased's entire estate be distributed to her on the basis that she was the domestic partner. I want to look at Sally Ann's relationship with the deceased. So they've known each other since they were children. But in 2016, they reconnected and commenced an exclusive, intimate relationship. And in 2018, the deceased moved in with Sally Ann in her rental property and began contributing to the household expenses. They continued to share love and life of affection. They had shared friends, they travelled overseas together, celebrated special occasions, went out for leisure and social engagements. They also maintained a relationship with each other's children, and the deceased even helped raise Sally Ann's son who had lived with them. Now in 2020, Sally Ann and deceased bought a property in Sea Lake. They intended that property to be a retreat and eventually their home for retirement. So the deceased paid the purchase price, and it was agreed that Sally Ann will continue to pay rent and expenses at their other property, which they lived, and the deceased would pay the expenses relating to the Sea Lake property. Look, unfortunately, as we know, in October 23, the deceased suffered a heart attack while visiting his son in Mexico, and he died on 13th November 2023 with Sally Ann by his side. Now, Nick, how does the law define a domestic partner, and did Sally Ann meet that definition?
So the term domestic partner is defined under the Administration and Probate Act, and it's defined as including both what is known as a registered and an unregistered domestic relationship or domestic partnership. So in Victoria, it's actually possible to register a domestic relationship. Now, a domestic relationship in this context is something other than a marriage. So that's what we're dealing with in this context. And that's under the Relationships Act 2008 here in Victoria. But in my experience, it's quite uncommon for de factos to register relationships. So typically, in most cases, domestic relationships or de facto relationships, whichever term you want to use, are unregistered. And when you're looking at an unregistered domestic relationship, which is a domestic partnership or domestic relationship for the purposes of intestacy, you sort of look at a number of factors, and generally you're taking into account all of the circumstances of the relationship. So that's quite broad and necessarily so. And a lot of these factors are non-exhaustively listed under the Relationships Act, under Section 35. And it's nothing that will come as a surprise. You're sort of looking at the degree of the mutual commitment to a shared life, duration of the relationship, the nature and extent of a common residence, whether or not there was a sexual relationship, the degree of financial interdependence, and any arrangements between the two of them with respect to financial support. The ownership, use and acquisition of common property, care and support of children, reputation and public aspects of the relationship. And that last one is the most significant in a lot of cases, because here, of course, Christopher, the deceased, has died. So we're really dealing with one side of the story. So in a lot of these cases, not necessarily in this intestacy context, but more generally, the reputation and public renown of the relationship, because you've actually got something objective. You've got people coming forward and saying, yes, these people were in a genuine, bona fide domestic or de facto relationship. So that last one, in my experience, carries a lot of weight, certainly insofar as the court's concerned.
Yeah, but and that's a good point, because often we do see clients who say, I'm the deceased domestic partner, and then you say, okay, give me a little bit more information about your relationship. Now, in this case, clearly Sally Ann could fall into that definition of a domestic partner. But as mentioned earlier, the deceased was still married. And I want to talk a little bit about that. Now, he was married in 1990. They had 2 children. They separated in 2003. Now, there's no evidence that the deceased maintained any relationship with her since 2018. But as we know, and you mentioned before, Nick, that intestacy law in Victoria states that where there's multiple partners, they either got to agree on a distribution split, divide it equally, or make an application to the court. Now, Sally Ann submitted that the deceased's entire estate should be distributed to her as a domestic partner. So the court had to determine what distribution was just and equitable. Nick, what did the court take into consideration in their decision as to how this estate should be distributed?
So that term, just and equitable, appears under Section 70ZD of the Administration and Probate Act, and really that section goes on to say that the deceased person's estate is to be distributed in any way that the court considers just and equitable. So these words were actually used under a similar section in New South Wales under their Succession Act, and there's one judgment in particular that was applied in this case from His Honour Justice Helen in Bailey and Palombo, which interrogated what is actually meant by the terms just and equitable. There's a number of sort of terms of art that are used in legislation that often when you're interpreting legislation, you're looking at the plain and ordinary meaning, but of course some terms are inherently or necessarily loaded. And in this particular case in New South Wales, when Justice Helen was kind of interrogating what do these words actually mean, and that's something that as lawyers we commonly deal with when we're looking at legislation and what the words mean. So he interpreted it as being used to confer a very broad statutory discretion on the court that is equitable in nature. And what I mean by equitable in nature is that you're not only enforcing what is legal, but what is also fair in the facts, matters and circumstances of the case. So in terms of what the court should take into account when determining a just and equitable distribution in this context, again, it's a distribution order between multiple partners on intestacy. Yes. So His Honour Justice Helen observed, quite rightly in my view, that the nature of human relationships are infinitely various and complex. So that's basically saying that there's no one size fits all here or list of exhaustive factors. You've really got to take it as it comes on the facts, matters and circumstances before you. But that being said, he did offer some guidance, and none of these will come as a surprise when you look at the factors I just read out from the Relationships Act. You're looking at the nature and duration of the relationship again, the nature and extent of the deceased person's estate, which was significant in this case, which we'll come to a little bit later, I suspect, whether a surviving partner was being maintained, either wholly or partly, by that deceased person prior to their death, the present and future financial resources and needs of the surviving partner, the physical health of the surviving partner. Of course, that has an impact upon what their present and future financial resources and needs will be. And then at the very end, any other fact, matter or circumstance that the court considers relevant. So this is really quite a broad, equitable statutory discretion that's being applied in this instance. And given that it was a decision of the Supreme Court of New South Wales, His Honour Justice Moore, in deciding this case, thought that it was of significant weight, not only because it was a very considered decision, but also because it was considering a section in New South Wales that has a similar operation to the section here in Victoria, and the wording is very close. So Justice Moore was of the view that this decision was highly persuasive, and those factors that I read out, and by the way, that's not all of them from Justice Helen's judgment. There's probably, I think, from memory, 15 to 20, but again, human relationships are infinitely complex. And in this particular case, in applying those factors, he did find that Sally Ann and the deceased, as you said before, were really in a fully committed domestic relationship with each other. And there was no evidence before the court that Giambra and the deceased, as you said before, had any sort of relationship after the deceased ceased living at the property in Brunswick as a tenant in 2018. So that seems to have been a flashpoint, and I suspect led to some conflict. And they ultimately ended their relationship, at least in an emotional and financial sense, in 2003 when the property in Brunswick was transferred to Giambra. So we'll touch on this later on, but it's quite common in this context where parties to a marriage separate. You might consider it emotionally done, you might consider it financially done, but there's often a step that does get missed, and I'm sure we'll come to that a little bit later on, because that can have consequences in a legal sense, and it does. The other factor here was the deceased estate was extremely modest. It was roughly $277,000. So we're not dealing with an enormous estate. It's below the statutory legacy, which I'll come to later on. So really, in terms of any other views, interests that you should be considering, there's none other really that are relevant here when you're looking at Sally Ann as a bona fide domestic partner of the deceased and an estranged, albeit married, spouse in the form of Giambra. So Sally Ann and the deceased were also financially interdependent. That's another big factor here. So the deceased had serviced the costs of that property they'd acquired in Sea Lake, you mentioned before, that they'd purchased together, and it was their intention that that would be their eventual home and retirement. Sadly, they never made it that far. And while Sally Ann was meeting the costs of renting a property in Cranbourne that the deceased was moved in, after he'd moved out of the Brunswick property. So they did maintain a common residence. And while he also made some contributions to the Cranbourne property, there was sort of an interdependency there, or a level of financial support that was agreed between the two of them. Again, highly persuasive. And the court also found that Sally Ann was in a fairly weak financial position. Now, to a number of listeners, when I read this out, this might not necessarily sound like a weak financial position at first instance, but she ultimately had a half interest in a Sea Lake property. She had savings of about $370,000 from an inheritance from her mother's estate, and she'd also received the deceased superannuation death benefit of about $170,000. So while that all sounds like quite a bit, given her age and physical health and her inability to work, she only had superannuation member balance herself of about $72,000. And she'd also recently applied for the disability support pension in light of her savings that were rapidly being depleted by, as I understand it, monthly living expenses that were far in excess of her income. So again, it sounds like a fairly strong position, but when you're kind of extrapolating it over decades, that kind of longevity case, clearly there is need there. And that coupled with a number of health issues that she was suffering from, the judgment doesn't go into detail, and nor should it in my view, but it sounds like they were compounded by the deceased's death, as you would expect. And of course, that's going to affect her present and future financial resources and needs as well. And ultimately, the other factor here was that Giembra, as the estranged spouse, she was on notice of the application and took no part in the proceedings. So she didn't file what's known as an appearance, and she didn't appear at the hearing. That's entirely a matter for her. There was clearly some acrimony following the deceased having moved out of the property in 2018. She took no part, so there was no competing claim, if you like, that had to be weighed up by the court in determining that the whole estate should be awarded to Sally Ann under the distribution order on intestacy.
So basically the court concluded that it was just and equitable that the whole of the deceased estate be allocated to Sally Ann as a domestic partner, and there was no distribution made to the estranged wife. Look, I suspect the size of the estate was also a relevant factor. Nick, what's your view? If we were dealing with a bigger estate, like a multi-million dollar estate, do you think the court would have exercised its discretion differently, and could there have been a different outcome?
It's a really good question, because here we're dealing with a situation where Giembra, the current spouse, I should say, because they were legally married, chose to take no part in the proceedings. So in some contexts, the courts may be tempted to appoint what's called a contradictor, which is counsel to effectively stand in the shoes of someone opposing an application, but that's more common in ex parte applications, or where someone's just applying to the court without a defendant named.
Yes.
But again, the court would be, in this instance, protecting the interests of someone who clearly doesn't really want to take part in the proceedings. And again, that was a matter for Giembra. That was a decision she made, and it should be respected. And
that might have worked out in Sally Ann's favour, because
absolutely
there was no competing application or order.
No, that's right. And I think as well, the size of the estate being below the statutory legacy, again, it was below that $600,000 amount. And it would have been interesting to see how the court would have tackled this, or the principles from Justice Hallen's judgment it would have weighed up in reaching, say, a different result, or perhaps procedurally taking a different approach. But I think given here that Giembra just didn't really want to participate in the proceedings, I think that was a particularly significant factor in ultimately awarding the whole estate to Sally Ann.
Yeah. Look, unfortunately, you and I both know Sally Ann's situation is not uncommon. I mean, I've acted in numerous matters where couples have separated, moved on with their lives, entered into new relationships, but they just haven't taken that final step to formalise their divorce. So they pass away without a will, and as a result, their loved ones are dealing with this mess, and usually ends up in the courts, which can be really costly. So the reality is, I think this dispute could have been avoided if the deceased basically formalised his divorce and made a will. I mean, it sounds so simple, but that's really what he could have done, which he didn't, unfortunately. Nick, so what are your final thoughts on this?
Look, I agree. I think, while I said before that the deceased and Giembra may have considered that their marriage was or had ended in an emotional and financial sense. They had emotionally separated, they'd physically separated, they transferred the Brunswick property into Giembra's name, so that might have been, at least from their perspective, the most significant financial asset that had to be dealt with. So in a lot of people don't realise, however, that when you're dealing with property settlements in a family law context, so that's not the emotional side, that's the financial side, the court still has to formally order the formal dissolution of a marriage. And that's actually a separate proceeding. And that's commonly not done concurrently with a property settlement in a family law context, because if the court dissolves the marriage, that limits the time, at least that's my understanding, in which a property settlement either has to be made or the time in which you have to consider it. So it's not uncommon for parties to a marriage never really to take that final step and dissolve the marriage via a decree absolute or decree nisi, as I believe they used to be called. And again, they've separated in that kind of emotional and financial sense, but there are still legal consequences to remaining married. And what's really interesting in this case, I think, is that I touched on before that the two children, Giembra was their mother.
Yes.
And again, the size and nature of the estate below the statutory legacy was only $277,000. But in terms of the what ifs and what could have been different here, I mentioned before that we were only dealing at that multiple partner level on intestacy because the two surviving children, Giemba were as their mother.
Yes.
And one of those multiple partners was being considered. So in the event that he had formalised the divorce, then Giemba wouldn't have been considered a partner on intestacy. And that would have fundamentally, I think, changed at least some of the considerations made in this case, because under the laws of intestacy, in that situational scenario, you have children from a prior partner or a prior marriage or relationship. The partner who has survived is not their parent.
Yes.
So then the split is fundamentally different. And in this case, my understanding is that it would be the statutory legacy or $600,000 and half of the estate to the partner. In this case, it would have been Sally Ann.
Yep.
And the remaining half would have gone to his children had they formally divorced. Now, because we're dealing with an amount below the statutory legacy, again, the statutory legacy is $600,000.
Yes.
The result wouldn't have been any different because Sally Ann would have got the whole sum anyway on intestacy. But at the very least, that formalisation of the divorce in a legal sense, there would have been consequences in terms of the need for this case to have run, because if they had formally separated and the marriage was dissolved, then Sally Ann, as the only surviving partner, notwithstanding the children would have benefited potentially if the estate were larger, being below the statutory legacy, she just simply would have got 100%, and this application may not have been necessary.
I mean, it gets messy, doesn't it?
It does.
It just comes back to what you and I have both been saying. People really need to get a will. And if your circumstances change, like you get into a new relationship, you leave an old relationship, go and review your will, or if you haven't got a will, make a will.
Yep, absolutely. And that, I mean, in our area of work or area of law, that goes without saying. Yep. And I think it always needs to be emphasised. Don't put it off. It's always recommended that people seek estate planning advice and sign a will that ultimately reflects your intentions, insofar as not only distributing your estate, but also appointing an executor or someone to administer your estate when you pass away. And in no circumstances, in my view, should you be really leaving that up to the intestacy provisions. They do exist, but they're not really, or they shouldn't be considered to be a safety blanket, if that makes sense. So you shouldn't be really relying upon them to distribute your estate or determine who will administer your estate on intestacy. I think it goes without saying that it's very important, and everyone should have not only a valid current will, but a valid current will that reflects as close as possible your personal and financial circumstances upon your death. Yep. So I think the only thing worse than having a will is potentially having a will that doesn't reflect your personal and financial circumstances when you die, which sometimes is unavoidable.
Yep.
But even if you have a will, just every now and then turn your mind to it. You know, you can keep it in the back drawer. That's not to say you have to update it every 6 to 12 months, but just think about it every now and then, because it can save a whole lot of pain. Yeah,
absolutely. Thanks, Nick. Well, that's today's spill. Thanks for sipping along with us on Wills and Spills. Cheers,
Thanks,
Nick.
Linda.